welcome to this next exciting episode of Beverly Hills Bar Association's ongoing CLE events. I'm Mark Hogue, chair of the Beverly Hills Bar's new AI in the Law section, which, by the way, keep your eyes open. We'll be launching our first event towards the end of this month. So I'm delighted to introduce today's speaker, Michael Colantuono. So Michael is the managing shareholder at Colantuono, Highsmith Whatley. He's one of California's leading experts on local government revenues. He's argued 14 cases in California Supreme Courts, appeared in all 6 of the California district courts of appeal, as well as trial courts around the state. And he has argued in the Ninth Circuit as well. He serves on the California Judicial Council's Appellate Advisory Committee and served on its Appellate Case Flow Working Group. So with that, I hope you're all sitting comfortably. Let's kick things off. Michael, take it away.
Thank you, Mark.
My pleasure.
And while my slides are queuing up, I should point out what wasn't in my bio. I'm not an AI lawyer in the sense that I advise participants in the AI industry. I'm not an intellectual property lawyer. I don't represent computer and software companies. AI is something I use in my practice and in my business. I think a lot about it, but ultimately it's a sideline. My primary business is as an appellate advocate, often for local governments. So with that, let's dive into our topic, which is how do I use artificial intelligence tools in analyzing an opponent's brief and writing my reply to it? And this workflow is my workflow. It is idiosyncratic, doesn't need to be your workflow, but it might give you some ideas. It works for me both in trial and appellate courts, and it's really the nuts and bolts of lawyering. How do you read an argument? How do you analyze an argument? And how do you put together your response to it? So here's my agenda for the hour I am to spend with you. I'm going to talk about my approach to reply briefs and the 6 steps along the way of reviewing my own case first so I remember what I'm arguing. I've put together a top-line outline of my reply, something that looks maybe like a table of contents. And only then do I review the opposing brief so that I review their arguments fully reminded of what mine are. And then I annotate their brief, usually with sticky notes and a PDF. And then I build on my outline, collecting all of those sticky notes and refining it. And AI tools can help refine it. And then I draft, and then I edit, and then I finalize, a lovely bureaucratic word. I also, along the way and at the end, I'll have some practical tips about particular tools in the marketplace where I will give you my opinions, which are worth exactly what you paid for them. You're entitled to your own opinions. And then I'll review the tools that I use, how I use them, and why. So that's our path for the day. So let's go ahead to the next slide. So to introduce, generative AI went public, so to speak, in late 2023 when ChatGPT was launched as a free tool on the internet. Prior to that, people in the industry understood the power of this technology, but it didn't become the cultural phenomenon that it now is until then. Now these tools are mature enough that lawyers should be thinking about how to integrate AI into your workflows because your clients are going to expect it, your competitors are doing it, cost pressures aren't getting any better for us or our clients. It's just coming. You know, there was a time when you could resist email, you could resist the conversion from WordPerfect to Word, you could resist the conversion from a Wang writer to a PC. All of those technologies are obsolete, and a law practice without AI, to my mind, is becoming obsolete. So today's question is not whether to use AI, it's how to use them ethically and effectively. Next slide. So how is AI useful for litigators in particular? Although I think much of what I have to say will apply to advisory lawyers or transactional lawyers too. One is it can save you time. I find it doesn't. I find the time I need to actually use the output from an AI product is as much as the time I save by letting it draft for me. But it definitely makes my work product better and makes my legal research deeper. It can help you identify issues, arguments, and authorities. And of course, we have an ethical duty under the rules of professional conduct to be competent. And California is leading the 50 state bars by reminding us in writing and expressly that competence includes technology. You know, there was an oral argument in the Supreme Court a few years ago. It was a Fourth Amendment question about what text explained between a police officer and the lady in his life who was not his wife, were unreasonably searched within the meaning of the Fourth Amendment when his employer downloaded them and looked at them. And there was this farce of an argument between the lawyers on the case and the justices of the US Supreme Court, in which it was very clear that none of them had the faintest idea about how pager technology of that time worked. In order to be competent, we need to know how the technology we're using and our clients are using works. Next slide. So what's the first step of my 6-step approach? I don't like to be too swayed by reading my opponent's writing before I remind myself of my view of the case. So if I've written an opening brief, it's easy. I go look at the table of contents and get refreshed. If the opposing party's paper is the first paper in the case, there would have been something that went before. Demand letters, a case analysis, correspondence with the client. So start by reviewing the file to remind yourself, ground yourself in your own view of the case. This allows you to reaffirm your client's objectives and your framing of the case, your story, how you think justice bends in your direction in this dispute. And it's intended to avoid letting the opponent's framing dictate your thinking. Unless, of course, you like your opponent's framing, and we'll talk about that again in a bit. Next slide. AI can help with file review. AI tools like ClearBrief, which my firm uses, are really good at taking in a whole lot of electronic data and organizing it, summarizing it, interrogating it. So you can query your factual database to, for instance, if you're in a personal injury setting and you want to look for every reference in the electronic record to notice to the defendant of the presence of the defect, you can ask ClearBrief to do that. And it's not doing a text search. It is using its ability as an AI tool to find other words that express the same idea that you're looking for. These AI tools can identify recurring themes, they can find factual patterns, but again, AI augments your work, but it does not replace your work. Your lawyer thinking, your legal judgment is still at the center of your work. Next slide. Let's talk about our first and most important ethical obligation when using AI tools. If you put something into the prompt of a public AI tool like ChatGPT or Claude, you should assume that you are training the large language model, that it's absorbing your data and putting it in its resource, and that it could use that resource to produce output to others. So it's necessarily a breach of confidentiality to put client confidences in the prompt window of a mass market, you didn't pay for it or you didn't pay very much for it product. So if you want to use those tools, you have to use them in ways that don't use client confidential information. That may mean being hypothetical. That may mean using false names. So sometimes I'll say, draft me an ordinance of a California general law city to regulate accessory dwelling units. I won't name the city. Or I say, draft me an ordinance for any town, California, that complies with the following 2 statutes and does the following 3 things. None of that is compromising my client's confidences because I didn't name my client. It could be any of the 483 cities. The second way to be consistent with your duty to protect your client's confidences is to use law tech tools, tools that are sold to you by businesses that know you're a lawyer and want to help you be a lawyer. Those tools assure you of confidentiality. You need to give some thought to what they're saying and how they're saying it. But generally, they guarantee your confidentiality in one of 2 ways. Either they run on your server and not in the cloud on their servers, or if they run it on their server, they delete it when you end your session. So, for example, I use Westlaw's drafting assistant regularly and launch a brief, get it to critique the cases cited and suggest other cases. It will critique the quotation accuracy. It will fix the citation form. It will tell me about coming changes in the law that might affect the cases that I'm arguing. In the end of each session, it says, I'm now deleting your copy. That's how it secures client confidences. It just doesn't keep it. So what are some of the tools out there that we're using these days? ClearBrief, which I've talked about, which is good at interrogating databases, does evaluate authorities, it does draft. I don't use it for those things. Logical, which is a tool for managing email discovery. That's the combination of logic and culling all of those emails for the ones that are responsive to discovery, for example. Westlaw's drafting assistant is a big part of my practice. Westlaw's Precision is their version of an AI-enhanced research tool, and I use it every day. I was using it a few minutes ago. We beta tested Lexis Plus AI and chose not to jump to it because they don't have the secondary resources that our practice relies on, particularly the Rudder guides. And of course, there are many others. There's a new product a month. This is a marketplace you need to keep an eye and an ear on in order to stay current. Next slide. So ClearBrief. ClearBrief summarizes and puts in chronological order case records. You can dump all of your electronic evidence into a ClearBrief database. We have a paralegal do that for us. And then ask for a chronology. And you can ask for a chronology that's short and general or long and specific. And you can ask for it in the form of a table, or you can ask for it in the form of a draft statement of facts. And for each item in the chronology, there's a link that you can click to and jump right to the evidence. I find this really powerful when getting started on a case. I've never used it to draft a statement of facts, but I do use the chronology to organize my thinking, to organize my team's approach, and we always start with an overlong one and trim it back. It will cross-check your citations. It will extract key issues. It's ideal for large records. In my practice, that's administrative records and large discovery sets. To give you an example, we had a CEQA case, a case under the California Environmental Quality Act. By the time it got to the Court of Appeal, there was only one issue left, and it was a particular human health impact. And although the standard of care required us to review the 29,000-page administrative record, it was very reassuring to use ClearBrief to make sure we hadn't missed any references to that issue. Something else ClearBrief does that's pretty powerful, it can turn your draft brief into a brief that has hyperlinks, so that each citation to a fact, you click it and you're in the record at that page. Each citation to an authority, you click it and you're in that authority. And it will bundle this into something you can file in court, giving the court effectively an electronic brief. We haven't used it all that much. I think some of my peers in the appellate bar use it a bit more, or use other tools as well. But those companies that will go hyperlink your briefs for you, they're going to die. This product and products like it are going to allow you to vertically integrate that function. Next slide. So what's step 2 in my 6-step workflow for reading my opponent's work and writing my reply to it? I develop a top-level outline, by which I mean not very detailed, table of contents level of detail, consistent with my case authority before I read the opposition. I may look at the table of contents in the opposition, I may scan it to get a sense of where they're going, but I don't study it yet. You can use AI tools for brainstorming. They're really good at that. So I'll give you an example. We got a petition for cert in one of our code enforcement cases for Humboldt County. It's in the paper today, actually, because we got cert denied on Tuesday, which is good news for our client. And we outlined in some detail our approach to writing the answer, the opposition to the petition for cert that the court invited. And we did that based on traditional research using the leading treatise for US Supreme Court practice. And then we talked to ChatGPT, the public version of ChatGPT, saying, we're lawyers, we're resisting a petition for certiorari to the US Supreme Court. We've made the following arguments about our case. What other arguments can you suggest that might be persuasive to the court based on what we've told you so far? It came up with 2 additional points that we ultimately decided to include. And the net result was the Supreme Court denied cert because our case wasn't a good vehicle for an issue that at least the conservatives on that court are very eager to take up. That's the kind of brainstorming that AI tools are really good at, giving you ideas for you to evaluate. And as you know, every lawyer knows, when you do an outline, you've got to organize the issues logically and persuasively. Next slide. You can use AI to spot issues and themes. So if you're in an area of the law you don't know well, or you have a case that's new on your desk and you haven't really absorbed all of its facts, AI is really good at recognizing patterns, generating ideas. You can use it to test hypotheses about case strengths or weaknesses. So you could say, I want to argue that the landlord did not have notice of the defect on the staircase. What facts are in the record can you identify that will support my theory? What facts are in the record that will undermine my theory? What's the strongest argument you think I can make that the landlord did not have notice? What's the strongest argument you think my opponent can make that the landlord did have notice? And these AI tools will answer all of those questions, some of them more persuasively than others. But you can ask these things. And of course, you'll see this on my slides repeatedly, you have to test its results with your own reasoning. You can't blindly take text generated by an AI tool and dump it into your brief. I do a lot of speaking on this topic. I work with Judge Carnow, who's recently retired from the San Francisco Superior Court, and with Jeff Ehrlich, who's an insurance coverage lawyer on the plaintiff side, who chairs the AI committee of the California Academy of Appellate Lawyers. And we swap news stories about what's going on this topic. And the one that came around today was the lawyer who got an order to show cause, why he should not be sanctioned for filing a brief that included hallucinated citations. And in his opposition, he included hallucinated citations. Somebody a little unclear on the concept. Why is this happening? I think it's happening for two reasons. One is lawyers are busy and in a hurry, and many of us are naive about how these tools work. Here's the most important takeaway from today's presentation. All AI tools hallucinate, even the ones you pay for, even the ones that are limited to a sandbox of authority. They make stuff up. Some AI tools have a temperature rating. The really cool ones are less creative, don't write quite as well, and are less likely to hallucinate. The warm ones are more creative, write better, and are more likely to hallucinate. Claude is warm, ChatGPT is cool, and the Westlaw product is cold. So be aware of that idea that even Lexis plus AI and Westlaw Precision, things sold to you as a lawyer, by a lawyer, for legal work, will hallucinate. The other thing that's going on is we all work in teams, and those of us who are leading a team have to trust the people on our team to an extent. And we can't go necessarily read every citation for every obvious principle. If you got a section of your opposition to a demur reciting the standard on demur, are you really going to go read each case that reminds you what the standard on demur is? Probably not. But we have to assume that the people on our team might be using these tools and might be using them irresponsibly. And my name is on that pleading. So we've established a rule in our organization that the lead lawyer on every filing needs to confirm the citations. And we do that using Westlaw's quick check, which is not AI powered. It's traditional computer, look it up in the database reasoning. And if there's a bad cite in your brief to a case that doesn't exist, or just a typo in the volume number or the page number, it will tell you. So our policy is before it goes out the door, the lead lawyer has to run the quick check. Yes, it's time consuming, but we're betting our reputation on it. We're betting our licenses on it. Next slide. So when you're outlining a brief, you can certainly do it the old-fashioned way, pull out a legal pad and write down your thoughts, or open your computer, pull open Word and start typing. But there are AI tools to assist with this as well. ClearBrief on evidence, ChatGPT and Claude with this conceptual brainstorming, but remember they're not confidential unless you've paid for a version of them that is. And Westlaw Precision and its CoCounsel tool, which we beta tested and basically decided wasn't sufficiently valuable to be worth paying. It will validate the authorities, identify authorities that you didn't cite or your opponent didn't cite that are relevant. These are really powerful tools. ClearBrief has a tool for evaluating how well a cited case stands for the proposition for which it's authored, but I don't find it as useful as Westlaw's version of that same tool, because Westlaw tells me in a plainer way and gives me other cases that establish the point, and they're right there for me to click on. Next slide. So what's the third step? You've reminded yourself of the case, you've done your top-level outline of your case and your reply. Now you do a strategic review of the opposition. So we're reading it only after framed our outline. And what I do is I read them as PDFs, because they come to me that way. And I put a sticky note on everything in the other party's brief that I have anything at all to say about. I try to maintain focus on my narrative, how I want to tell this story, not my opposing counsel's narrative, unless I like the way he or she framed it. If they gave something away in their framing, or maybe their framing is just simpler, clearer, and more persuasive, sometimes I'll adopt their framing. But when I'm done reading their brief, I've got a forest of sticky notes. And I collect all those sticky notes by putting them in the outline. And then I end up with an outline is what I call shrubby, kind of lumpy, too long in some places, too short in other, and lacking flow. And then my work is to clean up that outline, to make it flow, to avoid repetition. And then I start to draft. So next slide. How can AI help you with your critical analysis of your opposing counsel's brief? Well, certainly you can run it through ClearBrief or Westlaw's drafting assistant to verify its authorities. I don't do that much because I often work in areas of the law that I know really well. And so there aren't going to be very many cases cited that I don't know. And it's easier to just look up those few cases than to go hunt for all of them. But if you're in a new area, or maybe you're new to the practice of the law, it could be pretty handy to have a copy of the brief in front of you with a color-coded bar for each citation as to whether that's a good cite or not, whether that's a good case or not, or whether there's contrary authority you should be aware of. Westlaw's quick check evaluates your citation accuracy and your precedent strength. And as I said, it's the last thing we do before a brief goes out the door. Next slide. And I see that questions are starting to come in. I appreciate those. I'm going to come to those at the end of our presentation. Please feel free to add them now, however. When I review my opposing counsel's work, the reason I did an outline that draws from my side of the case is I want to identify things they didn't respond to. What arguments did I make that they just didn't respond to? Did they fail to rebut something? Did they concede any factual points? And then I argue the omissions as implicit concessions. So I often have a section at the front of my brief saying, there's less disagreement than may appear, and list all the concessions. Or fewer facts are disputed than one might assume. Or the following arguments are silently conceded, ... You can use the AI tools to cross-reference statements in your opposing counsel's brief to the record, and you can use it to cross-reference your statements to the record. So if they make a representation that the landlord had noticed at 8 a.m. on July the 7th that the stair was defective, you could highlight that sentence in ClearBrief and say, go interrogate the evidence and tell me what authority, what facts there are for or against that assertion. Next slide. I tag every point worth rebutting. I add them to my outline, and I include in my outline page cites to the opposition. The judges and their research attorneys want to know that your claim of what the other guy said or other gal said is accurate description of their argument. They want a page cite to where in the brief do you think they argued that black is white or white is black. So I collect the page cites, which is easy because the sticky notes are on pages. And I often find I'm using the contra cite. So I'll say, white is white and has been since the beginning of time. And to argue that black is white is fundamental error. Contra, opening brief, page 12. So I use that contra cite, not to say that one of my authorities has been contested, but here's where the other guy claims the other thing. Next slide. Step 4 in my 6-step process. I reviewed my file. I reminded myself of my case. I did my outline. I analyzed the other guy's brief and tagged it all up with sticky notes. Now I integrate my critique of his or her brief with the output of the Westlaw or ClearBrief tools. And I work on my outline to make it flow logically, cover all the issues. and I revise it to emphasize my narrative and my strategic priorities. If my opposing counsel devoted 8 of his 15 pages to an issue that I think is utterly dumb and refuted by a case cite or two, I'm going to put a paragraph at the beginning of my brief that says, this claim is utterly dumb, and here's 2 cases that prove it. Now let's turn to the art of the case. How many pages they devote to it should not dictate how many pages you devote to it, unless their pages were really effective. Next slide. So when I'm done with an outline, on projects that warrant it, everything we do doesn't necessarily warrant the full treatment, and the clients can't always afford it. But when the cost is warranted, I circulate it to my peers and to the clients to get buy-in on the outline. If there's something wrong with my thinking, I want to know it early. And I don't want to invest a lot of time in drafting, only to discover that the client or my peers don't like that drafting or are going to persuade me not to like it. So if you have time for this, this is really valuable. And when you get the committee approach to reviewing your work and general counsel wants to rewrite every darn footnote, you can remind them, this is due in 2 days, and I did circulate an outline, and you did sign off on it. Next slide. Fifth step in our journey towards a product we'll be proud of is the drafting itself. This is advice I give everybody who I train, everybody who's my peer, even to my clients if they want this kind of advice. Always draft from an outline, even from emails or short documents. It may be 3 points on a notepad, it may be 3 points that you've thought through and put in your head. Always draft from an outline. If you just sit down and start typing, you're going to wander and repeat yourself. So outlines keep your writing focused and efficient, and they allow you to avoid wandering or repetition. Stay on topic. Next slide. Last step is editing and polishing. Good to start with somebody who's a better writer than I am, an English writer from the 19th century, Robert Graves. There's no such thing as good writing, only good rewriting. AI editors can help you improve clarity, tone, and brevity. So my friend Jeff, solo practitioner, his son's a lawyer too, and sometimes helps him, had a brief that was over the 14,000 page word limit and was having a bit of writer's block about getting it down. He fed his brief paragraph by paragraph into CoCounsel and asked it to rewrite it in a shorter, clearer tone, and used its feedback to reduce the length of his brief. Now, he'll warn you that the tools tend to cut too much out. They tend to overdo it in trying to simplify, because lawyers often are arguing about subtle details and nuance. And what you might drop out for an executive summary for a general audience, you can't drop out if it's the heart of your case. I use WordRake. Well, let me put this differently. I make everybody who writes for me use WordRake. It's cheap, integrates with Word, and it will produce an orange line of your draft, highlighting common problems like passive voice, failure to maintain the right subject number with the verb, those sorts of problems. And I ask my team, before you ask me to invest my time in editing your work, you edit it using WordRake. It's like $600 a seat license a year. It's relatively cheap as this kind of software goes, pretty powerful. I recommend it. There are AI rewriting tools as well. We're not really using them so much, but we do use WordRake. Next slide. Use WordRake for concise legal wording in Word. CoCounsel can be used to assist with summarization and simplification. Next slide. A word about ethics. You should use AI output like the work from a junior associate. Verify all of it. Don't assume that just because a computer produced it in nice type, that somehow it's an authority. It's not. And do not delegate your legal reasoning to artificial intelligence. And always maintain client confidentiality. Next slide. Disclosure and compliance. First, disclosure to courts. Courts are increasingly requiring disclosure of AI use. There's been more than 200 lawyers around the country so far sanctioned for citing hallucinated cases. So courts want to know. Duke's Law School has a wiki. It's not a wiki. It's a resource that they maintain that lists all of the standing orders they know about from the courts around the country that have required disclosure of AI. A better rule is whenever you're in a new forum, an unfamiliar venue, check the local rules, check the standing orders, know what's required of you. You may well need a footnote in your brief saying, the research for this brief was supported by artificial intelligence tools. However, we did not use any AI-generated text. Or the AI-generated text produced for this brief was scrutinized by the lawyers who are filing it. There's something you may need to say. There's another kind of disclosure here, and that is the rules of professional conduct require us to disclose to our clients any significant matter affecting our representation. Do you think you need to disclose to your clients that you use email? Of course not. Do you think you need to disclose to your clients that you use Word? Of course not. These have become the bread and butter of all professionals' lives. But there was a time when each of these tools was new and to some extent controversial. I remember the debates about whether sending an email was consistent with our duty of confidentiality because somebody else might see it. Well, somebody might open your mail too. But I think AI is sufficiently new that it's best to make some sort of disclosure. So I have a little paragraph in my standard form of legal services agreement that says, you should know that we may use artificial intelligence tools in this representation. If we do, we will take every step we can to maintain the confidentiality of your confidences, and we will review any written output from these products to ensure it meets our standards and the standards of our profession. If you have any questions or concerns about our AI use, please let me know. I've been using that language for about 3 years now, maybe 2.5. Only one client has ever asked, and it's because he was in the AI space and wanted to do a little opposition research to see, well, what are you using? So think about what you have to disclose to courts. Think about what you might want to disclose to your clients. Next slide. The buck stops with you. If your name is on the pleading or you sign the pleading, it's on you. And you can't blame AI any more than you can blame your secretary. So AI can research. I use Westlaw Precision every day. It can summarize. We find ClearBrief really helpful. It can cite check. I use Quick Check every week. But it can't make your decisions for you. You remain accountable for the accuracy and integrity of the work you send out on your letterhead. Do not trust and do verify. Next slide. So what's in the marketplace? I don't have enough knowledge to exhaustively review everything that's going on out there. It's just, I read the paper closely, I pay attention to the stuff, I care about it, but it's a moving target. So I've talked about Westlaw Precision. It's the upgraded version of the Westlaw research tool that you're probably all familiar with. And when you open the Westlaw window, there's a traditional box at the top where you can do an ordinary search or a Boolean search. And there's CoCounsel down at the bottom, which I didn't pay for, but they still gave to me because I think they're learning that nobody's going to pay for it. And in the middle is a big window where you can have the kind of conversation that you may have had with ChatGPT or Claude. So, for instance, when I needed to produce these slides, I gave a paper that I'm using as the base of my discussion and the slide format that my firm uses with that logo and those colorful stripes to ChatGPT 5.0 and said, turn this into a PowerPoint presentation for my use. Please be detailed. I want at least 25 slides and don't step on my logo or my aesthetics. I didn't ask for pictures. If you ask for pictures and it has to generate them, it will take a long time. If you ask it to review a clip art file, it might be faster. But you can use it for, you can use these tools. You can use Westlaw Precision in particular. One of the things, often you're doing some work, you know there's a rule of law, and you need a citation for it. So for example, I know for a fact that a local government cannot commence an eminent domain proceeding to acquire property without a 2/3 vote of its legislative body. But exactly where in the eminent domain law and the Code of Civil Procedure that citation is not something I carry around in my head because I visit that area of practice. I don't live in it every day. So rather than ask an associate to go look it up or even try to find it with a Boolean search of the statutes in Westlaw, I just go to the Westlaw Precision window and say, find me the section of the community of the eminent domain law in the California Code of Civil Procedure that requires a supermajority vote to find necessity to acquire private property. And it goes away and cooks for a few minutes, and suddenly it gives me not only the citation, but I can click on it and open the statute, and it will give me several cases applying that statute. Much cheaper to my client than having an associate go spend an hour learning this, much cheaper than having me hunt around for 10 or 15 minutes if it can do it in 2 or 3. And you can use that Westlaw precision analysis to ask broader questions as well. So they're powerful tools. I recommend them. Drafting Assistant is a Westlaw tool that's been around a while. It uploads a document, evaluates the authorities, flags any weak ones, identifies ones you might want to think about citing instead, tests how accurate the quotations are, can check your citation form, and you can say, I want Blue Book or I want the California Yellow Book. It's a powerful tool, and I use it all the time. ChatGPT and Claude, we've talked about. I don't use them very much for legal work. I use them for marketing. I use them for firm management. So to give you an example, we added a position on our accounting team that we hadn't had before. I didn't have a job description conveniently at hand, and I needed one. So I said, ChatGPT, buddy, I need a job description for a financial services manager for a law firm that has these primary functions. And poof, it very quickly generated a kind of long and wordy, overdone initial draft. ChatGPT, when it was trained, was given more points by its initial critics for longer answers, more discursive, more chatty answers. And as a result, it's long-winded and a little inefficient. Claude is really friendly, almost to the point of being sycophantic. And a lot of these tools are, because they were trained to please the people who are working with them. And that sycophancy can contribute to your trusting them to overlook their hallucinations. And it leads to the mental health challenges that particularly young people have had when they've struck up friendships with these AI tools. Logical is a tool for taking a whole lot of email in, and first thing it does that's most powerfully important is it deduplicates. As you know, each email that goes out to 30 people and produces 30 or 40 or 50 responses produces this echo chamber where the same email bounces around and around and around. Logical immediately dedupes and reduces the number of emails we have to look at by a quarter or more. And then it allows you to quickly flag relevant and irrelevant, hot docs and not hot docs, things that shouldn't be in your data set at all. And it allows you to collaborate with the rest of your team in that way. So we use it on all of our cases. We used to be able to buy it project by project, making the pass-through of the cost to our clients really seamless. Then they got bought, and the new person the new owner who's busy trying to destroy the product insisted on changing the economic relationship so there's a flat sum every month. But they give you data that you can use to bill through to your clients. It's a little harder than it looks, because if you do just what they say, you end up overbilling your clients and you're collecting more than you're spending, which is unethical unless you've got your clients to agree to it. So the problem with a lot of this whole space is when a product gets really good, it gets acquired. And the person who acquired it often destroys what's best about it, like the people who just bought Southwest Airlines. Another story. Copilot is something that is available to all of you if you have the Office suite. It's pretty cheap. And what it does is it integrates ChatGPT into the components of Outlook. So your email box, your Word sessions, your PowerPoint sessions, your Excel sessions, all of those Windows Suite tools can have an AI interface built in. It will suggest words as you type. It will flag grammatical problems as you type. It's pretty cheap. And it is the most commonly used AI tool in America today because it plugs into everybody's workspace. It's pretty cheap and it's pretty helpful. It's not ChatGPT 5.0. It doesn't have the power that these other products have. Some people find it insufficiently helpful to be worthwhile. We offered it to our 34 folks, lawyers and support staff who have the Windows licenses, and only about half of them took it. And we've encouraged people to sign up and drop out whenever you want, because you can drop the licenses and stop spending money on it. And I'm going to keep an eye on it. We've just rolled it out. Some people swear by it. Some people don't use it. Your mileage may vary. And we've talked about ClearBrief, which my firm does use. We spend something like $67,000 a year for seat licenses for 37 lawyers and 5 paralegals. And so far, we find it worth it. I suspect that ClearBrief is probably not going to survive. It's going to get acquired and built into somebody else's product at some point. And the reason I say that is it's really good at certain things, but it only does certain things. And there are other products like Westlaw Precision that will eventually do everything ClearBrief does and other things too. So don't sign any long-term licenses. Don't commit, Lexis will tell you, come on over, we'll give you a discount. We want 3 years. Don't do it. Don't go longer than a year because all of this stuff is changing. So we tested Lexis plus AI. We put together a beta group of 4 lawyers and a paralegal, and we tested CoCounsel. On the CoCounsel project, some people loved it. A lot of people were kind of indifferent to it. And of the 5 people who started, 2 of them asked to keep their licenses after the test was over. And we let them until Westlaw acquired it and then started asking for a whole lot of money for it, at which point we let it go. But CoCounsel is a generative AI tool that uses legal resources and your resources to produce text for you. We tested Lexis plus AI, and we thought it was pretty nifty. The reason, and it was cheaper than Westlaw, but we would have had to ask everybody in my organization to give up all the treatises they've become comfortable with in the Rudder series and in a few other series that Westlaw has the exclusive license for. Lexis has competing products on all of those lines, but I just didn't think that the modest cost savings, it was like 20 or 30 grand a year for the whole firm, and the coolness of the new tool and its apparent utility really justified throwing a wrench in the workflow of everybody on my team. I didn't want to get lynched by my team. There are other players out there, of course. Harvey AI is really expensive, something like $1 million a year minimum licensing fee. It vectors your own databases. So it trains the model on your precedent. It can produce precedent in your style and in your voice. My impression is only the really big AmLaw 100 firms use Harvey. vLex's Vincent is a product that is heavy on the law of other nations. So those of you in a transnational practice may know more about this product than I do. And as I said, there's a new product a week in this space, and these are just the ones that I've given some thought to. So rapid innovation in this industry requires periodic reassessment by those of us who consume its tools, and you should expect continued evolution and specialization. The flavor of the month right now is agentic AI, which is using AI to create agents that do things, like operating a chatbot, like making travel reservations for you, like taking minutes at meetings. Lots of agents are proliferating, and there are tools out there that allow you to create your own agents if you're at all software handy. So a lot of evolution, a lot of specialization, and really niche tools are coming. My partner, my colleague who is our chief financial officer, is looking to automate the way that we check our balances in our bank statements each month. Reconciling the bank statements is essential, both to fulfill our ethical obligations on the client trust account, but to make sure that we're not getting stolen from or that we're mismanaging our finances. That's tedious. And if somebody makes a mistake in the way they code a particular transaction, it can take hours to figure it out. He's putting together an agent that will cut down that time for him and eventually do it for him. And I suspect that he'll get there. And then eventually somebody in the industry will come out with a product designed just to do that. We'll reconcile your bank accounts for you. That's the kind of specialization that I think we'll be seeing. Next slide. Closing thoughts before I turn to the Q&A, and I've left 15 minutes for Q&A. I've said this several times, but I'll say it again. AI enhances but cannot replace legal expertise. You're still the lawyer. Your license is still riding on everything you file in court, everything you send out on your letterhead. So use these tools thoughtfully, but don't be afraid to use them. I think they're powerful, helpful, and your competitors are using them, and you should. So I end every presentation on every article. You may have seen my columns in the Daily Journal about this with "Come on in, water's warm." And I think the next slide will say questions. And it does. So let's open the questions and see what we got. So Ralph Lamarande says, my understanding, which could be wrong, is that all the AI legal programs are relying on and based upon the public services such as ChatGPT, Claude, Gemini, etc. If this is true, other than confidentiality issues, what are the main advantages in utilizing the fancy and pricey legal specific AI services? It is true that producing a large language model, or an LLM, is hugely expensive, and maintaining and operating one all the more so. That you talk about the power and the water demand and folks who are wanting to reactivate nuclear power plants to run these things, it's a huge endeavor. So the back office, so to speak, is going to be one of the 3 or 4 main large language models. But that's a little bit like saying, because all the chips in computers were at one time made by Intel, I don't need a computer. You do. You can't really make good use of these large language models without a front end, and the front end's really different. The ChatGPT, Claude, and Gemini tools that you can get for free or for a low cost are using the entire internet as their information base. And they give no more authority to a Supreme Court opinion than your drunken uncle's rant. All of it's text, and it uses it all alike. So you'll get more controlled outputs relying on what I call a sandbox, a defined universe of quality stuff, if you use the AI-specific legal services. But if you're not ready to buy them yet, you can still use these other tools. You just have to know they're not as powerful and that they will hallucinate, particularly about legal stuff. Okay, Jeff Brandstetter, you mentioned that Westlaw Precision was cold on the hallucination scale. In your review of LexisNexis's AI tool, did you find it equally cold or more likely to hallucinate? I don't really remember, but I suspect that all of the tools marketed to lawyers are going to be cold, because think about who they're selling to. If you show up in court on a sanctions order because of hallucination, are you going to be happy with your vendor? Probably not. So I would expect the law tech tools to lean on the cold side, but I'm just speculating here. I don't know. Daniel Smith asks, what product do you recommend to edit your brief for clarity, brevity, and simplicity? Primarily, I use WordRake. I know colleagues who will use things like CoCounsel or ClearBrief or ChatGPT or Claude. It's a little awkward. You got to cut it paragraph by paragraph and dump it into the window and ask for an output and then absorb the output. I think that's a little too clunky. I'd rather just use my own editing skills, but WordRake is really helpful because it gives you an orange line underlining everything that requires your attention. David Azar says, what blogs or news sources do you find have the best updates for developments in AI for legal work? There's 2 that come to mind. One is the ABA has a law tech newsletter that comes out every week. I can't get past the stories into the content because I'm not paying to be an ABA member, but just reading the headlines often sends me out to the general internet to go find that story. So the ABA's law tech tool is pretty useful. And then there's something that I subscribe to that shows up in my personal email box, and I'm blanking on the name of it, so I'm going to go look. And I look at this periodically too. I signed up for the wrong one and got one that was aimed at coders, and I'm not a coder, so I sort of have to ignore that one. But there's another one that is pretty useful. Let's see if I can find it for you quickly without wasting anybody's time. Byte Go, I think, is the one that's aimed at people who code. And I'm not quickly finding the other tool. But you might just go out on the net and look for, or go into, look for a Substack that follows law tech, and that follows AI. There's a bunch of them out there, and you'll find one that's pretty useful. If you're looking at this more from the policy side, there's a professor at the University of Pennsylvania's law school who writes a Substack on this subject as well. But that's not practical. That's more top level theory kind of stuff, not quite academic. Okay, how about the use of AI generated videos and photos in trials and as evidence? What if it's being used by the litigants and their attorneys to mislead the courts? AI can produce images. AI can generate videos. My birthday was this week. Somebody sent me a video of Kevin Bacon singing me happy birthday with a pig playing a harmonica. It was very funny. I laughed. It lasted like 3 minutes, and I'm quite sure that Kevin Bacon did not sing me happy birthday. These technologies are kind of amazing. They're suffusing the world around us, and they're gonna make their way into court. And as Justice Streeter on the First District said on a panel I was on, the whole idea of trials is built around resolving disputes of fact based on reliable evidence, using a set of rules, arguments, and jurors to separate fact from fiction. Authenticity is one of the fundamental ideas of our evidence system. And how can you authenticate anything in a world of deepfakes? I don't quite know the answer to that question. I think we're all going to be struggling with that question. But I think we'll use the tools we have available today, which is to say, does it look plausible to you? Does it have any timestamps or other, does it have a paper trail? Does it have a Genesis trail? Is it legit? So we'll use the tools we've got available. I think the industry recognizes this problem too, and they're going to start using things like watermarks to authenticate their outputs. But yeah, non-trivial question, very limited answer because we're all really checking on it. So Jack Russo asks, is QuickCheck really bulletproof? I think so. The reason I think it's bulletproof is, what am I asking it to do? I'm asking it to confirm that an authority exists and that it has not been overruled. Well, Shepard's has been doing that ever since it was called Shepard's Gummed Citations, where you had a list of cites that you glued into your paper book. When was the last time any of you opened a volume of Shepard's? None of us do that anymore. We go into Westlaw and we open KeyCite. Well, QuickCheck is just another front end for KeyCite. And it is not AI technology. It's just looking things up in databases. So if I can't prove it's hypnotic, the judge can't either. Judge is using the same tools I'm using. So I think QuickCheck is a very it's the safety net that I'm prepared to rely on. So Ralph Lemarande says, can you compare WordBreak versus Grammarly? No, I haven't used Grammarly, but I will tell you that every time I talk about WordBreak, people in my audience bring up Grammarly. So it's got its fans. It must be a good tool, but I've never used it. Elizabeth Newton, which AI tool did you say you used to convert your PowerPoint template and documented AI use cases into this presentation? Is the tool reliable? I used ChatGPT 5.0 to produce these slides. And the output was a pretty good summary of the paper that I started with. It did use my format, protected my branding. All the text was too small. I had to increase it from 18 points to 30 points. It skipped a few points that I thought were essential, and it repeated itself a bit. You'll see that I repeated myself a bit, particularly when I was telling you, you've got to be the driver. You can't rely on AI. I left in some of the repetition for pedagogic reasons. I wanted to drill the point home. If I was writing a brief, I would be less comfortable with that kind of repetition. So I used ChatGPT 5.0. The only reason I needed 5.0 is I wanted some images, and ultimately I decided the images were taking too long and weren't that helpful. So I ended up with something that ChatGPT for free over the internet could have produced for me. Blockchain tokenization, or we go back to silver halides. I think that's right. The point that Ben Williams is making is one way to authenticate electronic artifacts is to associate a blockchain with each. And of course, blockchain technology is this technology that's used for Bitcoin and for tokens of various kinds that I'm told cannot be altered. The chain of provenance for that artifact is perpetual, perfected, and stored in multiple servers around the world. And I think Ben is quite right. That is how we're going to be authenticating these products going forward. So I see that I'm out of questions, but we are not quite out of time. I promised you an hour. I can go back to my overview slide and think of a few more things that I might like to say, or y'all can type quickly. So let me take a breath and a drink of water and see if there's any questions that will appear in my question box.
Okay. We actually did have one from the help desk that came through email. I do have one here. Any best practices for AI-aided issue compression so the reply focuses on dispositive errors the panel actually cares about?
Yes. I told you that these tools are wordy, and when you're in brainstorming mode, they can be especially so. I usually start with a over-inclusive product. I tell my associates and my colleagues, you can write about 10% long, because whatever you sent me, in just editing it, I'm going to make it 10% shorter. And if I think you've got arguments in it that I don't like, it's going to be more than 10%, which is why I get an outline first. But if they're writing from an approved outline, I can usually make anything anybody gives me 10% shorter just because I'm a good editor. These tools will produce too much, and you need to cut them back. The judgment about how to do that is ultimately yours. But if you got 25 points on the page and you only have room for 3, you might ask ChatGPT or ClearBrief or Westlaw Precision, of these 25 arguments, which 3 do you find most persuasive and why? I would not take its advice literally, but I would take its advice into account when evaluating these things. Somebody's asked if I've tried relativity, and the answer is I have not. Sorry. That was Joy Morris. Jack Russo, how is your firm handling hallucinations and opposition briefs? And he's citing Rule 11 and CCP Section 128.5. All I will tell you is, to my knowledge, I haven't encountered any yet. I've occasionally come across significant typos. I've had people cite cases that really don't say what they say, but that's been part of legal practice as long as I've been in this business. But I've not yet encountered hallucinations from the other team, knock on wood. Kathleen March, I use Westlaw Precision. Haven't had any occasion where it invented or hallucinated a case or a statute. Do you have any specific instances of that happening? Westlaw claims it does not happen. What I would point you to is a study done by 3 law professors that tested a whole range of AI products and reported the error rate. And the error rate for these tools was very low. It was as low as 1%. Whereas for ChatGPT, the internet version, the free version, it can be 20 or 30%. But it's still there. And Westlaw may deny it, but at least that paper said it's still there. And given that it's my license riding on it, I'm going to assume it's still there. I see we have 2 minutes. I don't see any open questions. Have you got any on the back office side there? Okay, Rachel Steinbach. Do the policies, protocols, and guidance that you provide your staff differ in any way depending on the level of experience? For example, do you allow your junior associates, first year out, otherwise inexperienced, to use AI as a junior associate? I'll let anybody on my team use it. I will sometimes direct people on my team to use it. I have often sent a paralegal who's particularly skilled in using ClearBrief off to generate the initial chronology. I've often sent one of my mid-level colleagues who's looking to draft something for a city for the first time where we don't have good precedent. I said, why don't you ask ChatGPT to draft one for you? Why don't you go see what an AI tool can do for you? It's not the end of the road. It's going to be a very rough first draft, and you still have to do your legal work. But I let anybody use it, provided that everybody in the team knows they're using it. And I've told it, we have a written policy on AI tools. We've just updated it because things have changed in the last 2 years. But one of the things it says is thou shall not conceal that you've used it, thou shalt report that you've used it, and the more senior lawyer is ultimately responsible for the product that was out the door. So Ralph Lemarande says, are you aware of judges now using AI for any reason? Hell yeah. The California judiciary has just published a policy about the use of AI in judicial administration. They have not yet touched the use of AI in the judicial process. There is a story you can find on the internet now where federal judges, I think in Mississippi, were found to have issued orders that had hallucinated content in them. So judges are human too. They're capable of making the same mistakes that lawyers are, and they're doing it. So I think you should assume the judges are using AI. And if you get an order that seems a little wonky to you, you might want to do a request for reconsideration and ask the judge to confirm that's what he or she really intended to say. It's 1:31. We promised you an hour. We've gotten there. I'm willing to stick around for another minute or so if there's another question or two. Otherwise, I'll send you all back to your other more productive pursuits. Ben Williams
Alrighty,
says
well,
thank you, and you're welcome, Ben.
This concludes today's presentation. Thank you so much, Michael, for your time, and thank you so much to your audience. Have a great day, everybody.